Hello everyone. In this session today, I'm going to talk to you and explain to you the Collegium System of appointment of judges in India. So, what is the exact procedure or the system that is followed insofar as appointment of judges to the higher judiciary? And when I use the word higher judiciary, I mean how are judges in the High Court and Supreme Court of India appointed? Now, we have certain constitutional provision relating to the appointment of judges. Similarly, we have certain important judgments which revolves around the appointment of judges in the higher judiciary in India. So in this session today, if you watch this session in the totality, you will get to know how are judges appointed, what are the constitutional provision, and what are the judgments of the Supreme Court relating to appointment of judges in India. Now, before we start, why are we discussing the collegium system? Very recently, the Union Law Minister has criticized the Supreme Court collegium system, saying that the judges only recommend the appointment or elevation of those they know and not always the fittest person for the job. So the law minister, Mr. Kiran Rijiju, the present Union Law Minister of India, Shri Kiran Rijiju, has criticized this system of appointment of judges, saying that judges or the collegium system which appoints judges are appointing or recommending the names that they know. Now, there might be a lawyer who might be absolutely brilliant, but the judges are not aware of that name. So that man is left out from being appointed. Now, in a country like India, we want an independent, robust judiciary. Now, over the last couple of years, we have seen criticism against the government, saying that the government wants their set of people in the courts, their mindset of people in the judiciary. Now, various speakers have criticized this move. Many judges of the Supreme Court has not liked the statement of the present law minister. Now, let's understand the system without getting into the politics of it. Now, Article 124 and 217 of the Indian Constitution, very, very important articles. Article 214 and 217 of the Indian Constitution deals with appointment of judges. Very, very important. So, Article 214, Article 124 of the Indian Constitution, deals with the fact that the President shall appoint a judge of the Supreme Court in consultation with other judges. So, I'll come to the provision in a minute's time. So, Article 124 deals with appointment of judges to the Supreme Court. Similarly, Article 217 deals with appointment of judges to the High Court. Now, these are the two constitutional provisions which are given under the Indian Constitution insofar as appointment of judges to the Supreme Court and the High Court respectively are concerned. Now, Article 217 and 124, let's read. 124 of the Indian Constitution says that every judge of the Supreme Court shall be appointed by the President after consultation with such of the judges of the Supreme Court and of the High Courts as the President may deem it necessary. So, the President is the appointing authority. Very, very important. The President of India happens to be the appointing authority. Now, how does the President appoints? The President consults judges of the Supreme Court based on the recommendation that the judges of the Supreme Court gives the President in consultation with the judges of the Supreme Court appoints. That is categorically what is given under 124. Similarly, 217 simply says that every judge of a high court is appointed by the president after consultation with the Chief Justice of India. So similar provision is provided under 217. So 124 and 217 deals with the appointment of judges to the Supreme Court and to the High Court. So the president is the appointing authority. The president, how will he or she appoint? The president, after consulting judges of the Supreme Court, will appoint a judge of the Supreme Court. The president, after consulting the Chief Justice of India, will appoint a High Court judge or the High Court Chief Justice. That is what is categorically provided under the Indian Constitution. Now, let's see how did this collegium system evolve. Now, there is not even a single whisper about the collegium system in our Indian Constitution. So the Indian Constitution does not speak about the collegium system. So how did it evolve? Now the collegium system is a system of appointment of judges in the High Court, in the Supreme Court, transfer of judges from one High Court to the other, and it is not by under any provision of the Constitution, neither it is done under any act of the Parliament. So how is it done? This particular system has evolved through certain judgments of the Supreme Court itself. Now, the Supreme Court of India has interpreted Article 124 and 217 in such a way that it has given birth to the collegium system. Is that clear? Now, let's understand the evolution of the system case to case. Now, initially, in the year 1981, which we commonly refer to as the first judge's case, in the first judge's case, the Supreme Court held that primacy of the Chief Justice of India insofar as recommendation on judicial appointment and transfer can be refused on cogent grounds. So, if the Chief Justice of India recommends a particular candidate to become a judge of the Supreme Court or to become a judge of the High Court, the executive can refuse such a recommendation on cogent grounds. That means it gave the executive, the government, primacy insofar as judicial appointments are concerned. So this particular ruling dealt with this fact that executive will have more importance insofar as judicial recommendations are concerned. Now moving on to the next important case which gave birth to the collegium system. Now this 1993 judgment, which is also referred to as the second judge's case, introduced the collegium system, and it held that the word consultation, which is provided under 124 and 217 of the Indian Constitution, means concurrence. Now, consultation, the Supreme Court interpreted the word consultation to mean concurrence. Now, there is a huge debate. Now, the word consultation and the word concurrence has two different meanings in our dictionary. Now, but the Supreme Court is the sole interpreter of the Indian Constitution. So, however the Supreme Court interprets the Constitution, that is final and that is absolute. You cannot challenge it. So, the Supreme Court in the year 1993 held that the word consultation, which appears under 124 and 217, means concurrence, right? Now, it added that it is not the Chief Justice's individual opinion that matters. It is the institutional opinion which is formed in consultation with two other senior most judges of the Supreme Court. Now, power corrupts and absolute power corrupts absolutely. That is all we know. So the Supreme Court says that if one Chief Justice becomes, suppose a particular individual who happens to be the Chief Justice is not a good, fair man. So what happens then? So the collective institutional opinion, of the Chief Justice along with two senior most judges of the Supreme Court will be taken into account insofar as the recommendation to the President is concerned. So in the second judge's case, the Supreme Court simply said that the word consultation, which is mentioned under 214, 214 and 124 and 217 is concerned. The word consultation means concurrence. Secondly, it also said that the Chief Justice individual opinion should not be taken. It should be a group of people. So Chief Justice plus 2. So here we see the Collegium having Chief Justice of India plus 2 senior most judges of the Supreme Court. So it becomes 3. Now, thereafter, in 1998, another case came up to the Supreme Court, wherein the Supreme Court expanded this 3 to 5. So CJI plus 4 it became. So the real Collegium was given birth in the second judge's case. Now, third judge's case only increased that quorum from CJI plus 2 to CJI plus 5. It's a 5-member body today. CJI plus 4 senior most judges of the Supreme Court of India. So the birth of the Collegium system was born in the year 1993 by virtue of the second judge's case. Now, let's now understand who heads the Collegium system. The Collegium system is headed by the Chief Justice of India, and it comprises of CJI plus 4 senior most judges of the court. So there are 5 total members. The CJI is the head of the Collegium system. Now, we also have a High Court Collegium. Now, judges of the High Court are recommended by their courts. So the High Court Collegium system is led by the incumbent Chief Justice of the High Court and 2 other senior most judge of that court. So CJ, Chief Justice of the High Court, and 2 other senior most judges of the High Court. Now, judges of the higher judiciary are appointed only by the Collegium system, and the government has a role only after names are recommended by the Collegium system. Now, the government definitely goes for an IB report, Intel report, and other reports, whether that person is corrupt, whether that person is not corrupt, how is he, what is he, how much has he earned, is there any cases against him. So the government does due diligence. It's not that the government does not have any role to play, but the government's role starts after a name is recommended by the Collegium system. I repeat, it is not true that the government does not have any role to play. The government does have a role to play, but it starts only after a name is recommended by the Collegium system. Now, the government does various things on them. For example, they do an IB check, okay? They do other checks about that particular candidate who is recommended to become a judge of the High Court or the Supreme Court of India. Now, what are the procedures for judicial appointment? Now, as you know, that the President of India appoints the Chief Justice and other judges of the Supreme Court. Now, as far as the CJI is concerned, the outgoing Chief Justice recommends his successor, and it is strictly by seniority. Okay, the next senior most judge is recommended. Okay, now when Justice UU Lalit retired, okay, you must have definitely seen that when Justice UU Lalit, the former Chief Justice of India, retired, he recommended the name of Justice D.Y. Chandrachud. Similarly, when former Chief Justice N.V. Ramana was retiring, before he retired, he recommended the name of Justice UU Lalit. Because Justice UU Lalit, during when Chief Justice N.V. Ramana was retiring, Justice UU Lalit was the senior most judge of the Supreme Court. So the practice has been that the senior most judge will be recommended as the Chief Justice of India. Is that clear to everyone? Now, let's now understand for how does it happen in Supreme Court. Now, other judges of the Supreme Court, okay, a proposal is initiated by the Chief Justice and the other 4 senior members of the Collegium System decide that whether that particular individual is fit to become a judge of the Supreme Court or not. They look into the judgments that the individual has given. So how has he behaved with the bar, that is the lawyers? Are there any complaints against that particular individual or not? So the Supreme Court, this collegium system, they sit together, the Chief Justice and the 4 senior most judges. They talk about the judgments, the quality of the judgments, how many cases have we disposed of, is there anything that went wrong against the Chief Justice and the members of the bar or the lawyers. So everything is taken into consideration, and only after that a candidate's name is recommended. Now, once the candidate's name is recommended by the collegium, it is sent to the law minister, who forwards it to the Prime Minister and then to the President for that individual's appointment. Now, the fact is that the law ministry over here does a lot of routine check. As I said, they do IB check, which is very open. Everyone knows that every individual's name which is recommended to become a judge of the High Court or the Supreme Court, there is a proper IB check and other checks, especially from ED and other government institutions. They do conduct various tests and checks on that particular individual. Now, for Chief Justice of High Court, how are the Chief Justices of High Court recommended? The Chief Justice of High Court is appointed as per the policy that the Chief Justice from outside is recommended. Now, the Chief Justice of Delhi High Court will be someone who would come from some other High Court. So the Chief of a particular High Court is somebody who has come from outside High Court. For example, the Odisha High Court Chief Justice comes from Delhi, right? Is that clear? Justice Muralidhar's parent High Court is Delhi High Court. Now, he is right now the Chief Justice of Odisha High Court. So, similarly, a person whose parent High Court is not from that particular state is recommended to become the Chief Justice of a particular High Court. Now, the collegium takes the call on the elevation. High Court judges are recommended by the collegium, comprising of Chief Justice plus 2 senior most judges. Now, Supreme Court collegium is Chief Justice plus 4 senior most judges. But High Court collegium is Chief Justice of India plus 2 senior most judges. The proposal, however, is initiated by the outgoing Chief Justice of the High Court, concerned in consultation with the 2 senior most of his colleague. The recommendation is sent to the Chief Minister, then to the Governor, and then to the Law Minister. As you know, that the executive does have a role to play insofar as judicial appointments are concerned. Now, so let's understand what are the issues relating to the collegium system. Exclusion of the executive. Now, people have this feeling that there is a complete exclusion of the executive from judicial appointments. But I do not agree with what people at large think about, because a recommendation can be sent back by the executive. But if it is reaffirmed by the collegium, they have to do it. But they have a say. It is not something that the executive is treated like a post office. No, it is not that. They do have a role to play. It's not that they have a great role to play, but they do have a role to play. There is criticism that there is no accountability to an administrative body, and this have led to wrong choice of the candidate. Now, over the years, we cannot say that all collegium appointments have been great appointments. Now, there have been good appointments, great appointments, and not so good appointments. Now, every system, there cannot be a system which is absolutely perfect in our country. No system is perfect. Now, there is definitely scope to get this system in a better position. But we cannot say that this system has absolutely failed. Okay. Now, there are chances of favoritism and nepotism. Yes. Yes, the collegium system does not provide any specific criteria for testing a candidate. There is no written examination for appointing a judge to the High Court or the Supreme Court. For example, you have a CLAT examination. There's a CLAT examination for getting into NLS Bangalore and other law schools across the country. But there is no such examination which a candidate gives to become a judge of the High Court or the Supreme Court of India. So this gives rise to a lot of people saying that there is a non-transparency in this particular system of appointment of judges, especially in the higher judiciary. Now, against the principle of checks and balances. Now, there should be checks and balances. If the executive does something wrong, it has to be checked in the parliament, that is the legislature. If the legislature does something wrong, it has to be checked by the judiciary. So there should exist a principle of checks and balances. Now, we have the legislature, the executive, and the judiciary. Now, the criticism over here is if the judiciary is doing an executive action. Now, under the constitution, the president shall appoint the judge. Simple. The president shall appoint the judge. Now, what has happened today by owing to various judgments of the court is the fact that today this power of appointment of judges is made by the judiciary. Now, it is an executive action which is being done by the judiciary. Now, however, the collegium system gives judiciary immense power and little room for checks and balances in this particular system, that I agree. Then it is a closed door mechanism. Now, people who are lawyers, they know how things work out, but an outsider thinks that 5 judges sitting in one small room having coffee or tea are appointing judges according to their own free will. No, it does not happen like that. They do take into account various factors: seniority, judgments, how many disposal of cases that have they done during their tenure, and other things are taken into account while deciding or recommending an individual to the post of a judge of a high court or the Supreme Court. Now, there are no official minutes of the collegium proceeding, but finally what comes out from the Supreme Court website is the fact that the Supreme Court has recommended A, B, C, D, E as judges of the High Court, as judges of the Supreme Court. So the final result of the collegium thing comes out, but what were the discussions inside the collegium system, no one is aware of. So people think that it is a closed door mechanism which happens within the collegium system. So there is a lot of criticism about it. There is unequal representation, especially the women and people from the backward classes. They are underrepresented in the higher judiciary. Now, you have 34 total strength of the Supreme Court, and as on today, you have just 3 judges in the Supreme Court who are women, right? Only 3. Only 3 out of around 28, 29 judges in total today. So please try to understand that yes, and over the last couple of years, many decades, over the last 7 decades, we haven't had a single woman Chief Justice of India. Of course, Justice B.V. Nagaratna will become the Chief Justice of India, but she will have a very small tenure, but very short tenure. Sorry. So, Justice B.V. Nagaratna will become the Chief Justice of India, the first woman Chief Justice of India in some years' time now, but she will have a very short tenure. But over the last 7 decades, more than 7 decades, we never had a woman Chief Justice. So the total number of women judges, if you calculate, is minuscule. Minuscule, okay? Many places you don't have women judges in the high courts. Now, what were the attempts insofar as reforming the appointment system of collegium system is concerned? Now, the government of India took this initiative of replacing the collegium system by the National Judicial Appointments Commission by amending the 99th, by amending the Constitution of India, by introducing the 99th Constitutional Amendment. But this constitutional amendment, NJAC, had a collegium system where you would have the CJI plus 2 Supreme Court judges plus law minister plus 2 eminent jurist. Now this eminent jurist would come from a panel which would have the CJI, the Prime Minister and Leader of Opposition. Okay, LOP. The Leader of Opposition, the Prime Minister and CJI would select 2 eminent jurists, the Law Minister and 3 judges. Now the Supreme Court held that primacy of judiciary, which is a basic feature of the Indian Constitution, primacy of the judiciary insofar as appointment of judges are concerned. Now, primacy of judiciary is, insofar as appointment of judges are concerned, is a basic structure of the Indian Constitution. Now, the Supreme Court in this particular case, while considering the legality or the constitutionality of the National Judicial Appointments Commission, held that the primacy of the judiciary insofar as appointment of judges by virtue of this Judicial Appointments Commission is concerned is taken away, and hence it held that this law or this replaced new collegium is violative of the basic structure of the country, of the constitution, and hence it has struck down the 2014 Amendment Act, because the Supreme Court said that if you have the law minister, if you have 2 eminent jurists, then there is a threat insofar as the independence of the judiciary is concerned. And hence, there is a lot of criticism, and the government is now free to come up with a new law for appointment of judges to the High Court and the Supreme Court. The Supreme Court did not take away that system. But till the new system comes, the old system of collegium system will continue insofar as appointment of judges to the High Court and the Supreme Court is concerned. So guys, I hope you understood this session on appointment of judges to the High Court and the Supreme Court of India by virtue of the various constitutional provisions which I have tried to explain to you, and the various judgments that I did explain to you. So do guys do subscribe and press the bell icon of our YouTube channel. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S Exam Prep app. Do like and subscribe. Thank you. God bless you. Have a great day ahead. Thank you.